Confessions of an Accountant, where no topic is off the ledger.
Lovely to meet you all today. I really appreciate the opportunity of sharing some tips and techniques on protecting intellectual property, your branding, your client's branding, and perhaps even family brands as well. Just by way of a short introduction, I've been trading now for 35 years, based in Rottingdean, just outside Brighton, near the marina, on the top of a hill, Beacon Hill. And the reason I'm called Clive is because if you look in the dictionary, Clive means cliff-top dweller.
I did not know that.
I do have a number of hats. So when I started out, having come out of corporate life, doing spin-outs for large companies for technology products and services, I started out life as a leadership trainer, working with the Institute of Personnel and Development members and also Institute of Business Consultancy members, who are now called Chartered Management Institute. And over the years, I've worked with many other professional bodies. I'm a life fellow of something called the RSA, the Royal Society of Arts. I've been used for many years as a trainer by the Federation for Small Businesses, and also used as a trainer by Chambers of Commerce. And my training covers not just intellectual property, but more recently, ESG, that means Environmental Social Governance accreditations, which allows small enterprises to work more easily in the public sector with what we call social value accreditation, because that's now a legal requirement coming through into the small enterprise sector. I'm also a certified mediator. Comes in very handy for intellectual property infringement cases. And on that subject, I will wear my hat, because you will see in my hat the letter R on the right side of DocuSign, which means that this is a registered trademark. And regrettably, very few small enterprises have protected and registered their trademarks. And this in turn has resulted currently in about 1 in 3 small enterprises being copied online and infringed. And either they are infringed or they create an infringement. If it's the latter, a small enterprise, typically a sole trading company director, is often sued on average for about £150,000 for a trademark infringement, and may lose up to 40% of their historical profits for a single trademark infringement. Why aren't you aware of this? I don't know. You may already be aware of this. Many companies aren't, many advisors aren't, simply because almost all of these cases are settled out of court under non-disclosure agreements, NDAs, which means that this is a sizable problem, which very few people are aware of. So I've got a quick question to you, just to capture some engagement. Do any of you come across, or have you come across, trademark infringements? Any thoughts from the audience? No? That doesn't surprise me, because this is sadly an iceberg situation. There's very little on the top of the on the surface of the water to indicate the size of the problem underneath the surface. So with that in mind, if I can perhaps give you an example, got someone who has registered the word Donna as a trademark. Yeah. So Donna, if Donna wants to use her name as a trading entity, she might come across a problem, because this trademark is registered for people in business services.
Wow.
And if I can perhaps quote a recent case study that I came across, a lady called Isabel Pearl started during COVID, company selling cosmetics, Pearl Cosmetics. Over COVID and past COVID, she ended up employing 8 people full-time and had a turnover of about £500,000 a year with a sizable margin. And she had stock holdings also £500,000 a year. Regrettably, she failed to do a trademark search online, looking at the trademark databases, and failed to see that another company called Pearl Cosmetics had registered their trademark prior to her trading. And the IP attorney for Pearl Cosmetics took out a cease and desist. He lost all of her stock to the trademark owner. She had to fire all of her staff. She had to cease trading. And they took her branding, and they even re-registered her personal name, Isabel Pearl, for their own ownership. And she's now having to start up afresh out in, I think, in Dubai, because she's even unable to use her personal name for trading purposes. So it's a big problem. And in the next 15 to 20 minutes, I'm going to share some examples of risks, but also opportunities related to trademark ownership. I welcome some Q&A after my presentation. So write down any questions as we go forward, or indeed, if you want to shout out as we cover this interesting subject, I'm happy for you to do that. But I'm going to be sharing my slides now, just 14 slides, so not too many to look at, and we can have a nice, interesting Q&A afterwards. So my slide share should be coming up in a moment. Do we have everyone able to see the slide share? Fantastic.
Yes, I can see.
Great. I just want to point out a couple of things on this first slide, and that is where I've highlighted in yellow, head of a curve. That is registered trademark under my name with a nice letter R in a circle designating registered trademark. That's me. Because too few people who own trademark show that it's registered, which causes even more confusion in the marketplace. But I mention ahead of a curve because it's a motto, it's a slogan. It's quite a nice one to own, actually. And how do I own it? Because it's not the same of the very common phrase ahead of the curve. In fact, I was very surprised when I made the application and ended up owning this wonderful phrase, because I thought it would be rejected for being too similar to a common phrase, but it wasn't rejected, and I'm lucky enough to own it. So consider, if you have any clients with a nice suitable slogan or motto, it can be registered, it can be owned, and it can stop other people using that same motto or slogan in the same trading sector. Mottos and slogans are highly memorable part of branding. You'll also see that I've highlighted Consult SMP. This is my domain name. My full brand name is Strategic Management Partners. It's a bit of a mouthful to put into a domain name, so I shortened it to Consult SMP. I've registered Consult SMP as a trademark. What this does, it means that I have automatic ownership over all associated domain names with Consult SMP. So when I receive a letter every now and again from China saying that they're selling consultsmp.cn.ru.us.net to other companies, and would I like to buy them? I say, no, I don't need to buy them because I actually have trademark ownership over those. And if you do decide to sell them, then the user can be sued by me because I'm the trademark owner. And indeed, if I choose to do so, I can counter sue you for selling it, or they may decide to counter sue you for selling it. Because any professional person or seller or advisor of trademarks or branding or companies' house registrations may well fall into the trap of consequential liability if, as a result of their professional advice or action, they have infringed a third-party trademark owner. And the consequential liabilities can be a full slap in the face of £100,000 financial penalty. Luckily, for many professional advisors, very few of those who are infringed are aware of the laws of consequential liability and third-party liability. But I'm starting to see more cases. So beware, accountants, beware. other professional advisors, such as marketing agencies, who are very happy to design brands, logos, trademarks, slogans, without checking first the trademark ownership registers, because they, at some stage, may become liable for significant losses. Then finally, you'll see on the bottom right, my own branding. It's quite similar to my business card there. So I've registered strategic management partners with a logo, because I can't register those as words because they are commonly used words. They are what we call descriptive. But by adding a logo or a design alongside, I've created unique distinction, and I can register that and own it. And you'll see under that, I've incorporated a short slogan as well. Values, sustain value, all in one application. So there's lots more to just the words that can be protected. And I encourage you to think outside the box and consider additional protections for yourselves or your clients. Let us move on if we can. So, what are the benefits? Well, if you own your trademark and you discover someone copycatting with Google AdWords above you online, if you've got a certificate, you just email that certificate to Google, Amazon, Etsy, eBay, and they will remove the offending copycat. But if you don't have a trademark certificate, you can't stop them. They may well stay up there above your name because they paid for it, and they may well take your inquiries. So it can be expensive not to have a trademark certificate. It improves your search engine optimization. Put my name, my business into Google Strategic Management Partners. Very common phrase, by the way. You'll find despite being a sole trading director working from home, this is my home office, I'm on first page because I protected my trademark. I don't have to pay for extra domain names and costs. And indeed, I don't have domain name competitors causing confusion against my brand. It also shows I've got some ongoing continuity in the marketplace. So it gives me some credibility when I'm dealing with other organizations. And then finally, licensing. If I want to license any of my activities or training content, I can do that more easily because I own the trademark. If I've got a registered trademark, it also reduces the risk of my business, which means I can get more public sector contracts. ESG, environmental social governance, is now becoming a requirement for small enterprises. And of course, by registering, I know I'm not infringing someone. So I'm not going to fall prey to those nasty IP attorneys who may otherwise want to collect, after 35 years, up to 40% of my revenue or profits. So there's lots of benefits here. On the downside, and I'll show you a few examples here. If you've got clients in the design or content authoring sector, they are at risk. Here we've got a very nice design sold for $328, but because the designer failed to spend £50 registering the design, someone else called Zara has copied them online and selling it for £49 or $49 instead. It's not expensive. We'll look at costs in a moment, but this is very common. Designers and content developers, creatives are losing a lot of money by not investing in design protection. On Companies House, great deal of interest for accountants, I believe. You will find that a lot of copycats exist. If you've got a trademark, as I have on Companies House, and I'm registered under Strategic Management Partners Limited, LTD, someone else might want to offer Strategic Management Partners, LIMITED, and they can do that. But they can't if I actually have registered my name as a brand. No. So beware that it also protects you with Companies House, but there are an awful lot of copycats, and it's very important to understand that copycats can take away money from the real business owners by actually pretending to be them and using their credit or selling or buying goods online and not paying for them. So this is a big issue at the moment. And this is why Companies House is now asking for additional identities of directors and verifications. But this will take them a long time to sort out because there are literally thousands of copycat companies online taking advantage of people's lack of protection on their branding. Bear in mind also that the ISPs, that is to say the internet platform providers, also copycat. So how often does this happen? Amazon have themselves seen 39% of their clients online copycatted. And indeed, in some cases, the ISPs themselves copycat a very successful product or service, particularly products online if they're not trademarked. So be aware that if your clients are selling anything online, and if they do not have trademark protection and a certificate that they can send to the internet service provider, then they have a big chance of being copycatted and losing money and losing their reputation. So this is also a big problem. I mentioned LinkedIn, by the way, because LinkedIn profiles are being scraped and used, and identities are being copied. And if those identities include a trademark or a design protection, then again, the owner of those identities can more easily stop that from happening. It's tough without official ownership of identity. Little example from last Christmas. Sadly, Martha Keith here designed a wonderful advent calendar with some brilliant presents behind each door as they opened every day. But within just a very short period of time, she found that there were 900 copycats of this product design. What the copycats were doing, that they simply copied her website, they scraped her website, put up fake websites with her so-called best value, extremely good product, which she was selling for £149. And they were offering those same so-called products for £49. They were taking the money and delivering nothing. And she had failed to register the design of her product. It would have cost her £50 to do that. But it destroyed her business last Christmas. She was in the papers. She took an exception also with Amazon, but Amazon didn't respond because she hadn't got official certified ownership of that design. So this is a common problem, and it does destroy a business very quickly. A couple of other examples. Easy Jet Wash. This is a sole trader in Yorkshire who was actually offering a jet wash service for driveways. But because he had Easy Jet Wash, the airline took him to court, sued him successfully, took 40% of his profits, took his vans because they had the branding, and he's had to start again. More locally, down the way in Seaford, I was at a open marketplace and I found Prohibition rum, but it had the big H, which was very similar to the Harrods H. I did advise the owner of this product, who was making it locally. It's very nice stuff, but actually Prohibition rum would all likely be prohibited by Harrods IP attorneys. So I recommended he changed his branding, because it can be as simple as a letter on a brand that creates a problem. And in the clothing industry, there's quite a well-known case where one clothing provider sued another clothing provider because they were using a similar logo, not the same. You can still be sued if you are using what we call in legal terms a confusingly similar brand. And if perchance you had been the advisor recommending this brand, or a marketing agency, or a designer, then you too could be sued for a similar amount for this simple mistake. Even in ignorance, it's still an infringement. But coming back to my statistics, these statistics are from the Intellectual Property Office across Europe. And you will see on the bottom left here that 24% of micro startups suffer infringement, 28% of small enterprises, 39% of medium-sized business. It's a lot of companies, which we're not reading about because they're settled out of court under non-disclosures agreement, but it's a big loss. It's an iceberg of a problem. So be aware. Let us ensure that we make known more information about IP protection and education and awareness on the subject. And we can't have a decent presentation without mentioning Trump, of course, can we? It says bottom left, a Brooklyn man must pay Donald Trump $32,000 damages because Trump has got lots of trademarks. He's very well known in legal circles. And he's equally known as somebody who likes to sue people. So he's let other people buy their domain names and decided to sue them. And he's suing, asking for $100,000 each, but he's only ending up, poor man, with $30,000 each. But last year, about 68,000 domain infringements took place. Domain name ownership does not protect you from trademark ownership. Trademarks trump domains. Well, can you protect it yourself? Yes, you can. But perhaps if I could warn you that last year about 10,000 do-it-yourself applications were failed. And the criteria were often not met for being distinct enough. People didn't do the searching up front. And by the way, if you don't do the searching up front, you put an application in, the Intellectual Property Office will automatically forward your application to other similar trademark owners so that they can take action against you. Horrific, isn't it? Yeah. So bear in mind, it's best to actually employ someone to make that search and also make that application on your behalf. Just for your reference purposes, a search, a lawyer may charge up to £2,000 to do. I may just mention, I do the same job for £250. It is an insurance. It stops people worrying, stops them getting infringed. Equally, trademark fees do not have to be high. We'll come to that in a minute. But let me just nearly complete by mentioning licensing, because some of your clients may have products or services that can be licensed to third parties. I've got lots of training clients, for example, who have training related content, or consultants with consultancy content, who can license their content online, not just nationally, but internationally. And indeed, giving you a single example, one of my freelance training clients has registered his course content as designs. He's provided that course content to 150 freelancers, freelance trainers, each paying him £2,000 a year, giving him an income of £300,000 a year for his training content. And what did that cost him in registration fees? About £1,000 to register and protect his content. So it's a great way to encourage your clients to increase their business size, their turnover, and indeed, they may even pay you more money for the service that you provide. Think of that. A word of warning, 9 out of 10 law firms are not qualified intellectual property advisors. So always encourage people to seek qualifications from their IP advisors. In my case, this is my certificate going back 12 years, where I scored the grand sum mark of 79% accuracy, which is actually quite good. Okay? This is a postgraduate qualification. delivered by not just the Intellectual Property Office, but by the British Library and a recognised university. On top of that, as I mentioned earlier, I'm a certified mediator, because mediators can resolve disputes much more quickly at a much lower cost. I've resolved many disputes already this year. Typical dispute time takes me about 2 hours to resolve and costs the client about £250. Had that dispute gone into the law courts, it would be probably in the region of £10,000 to £20,000 to resolve a trademark dispute, and it could take up to 2 years to do that. So bear in mind, mediation can be an affordable alternative to dispute, but always encourage people to seek the certification of their IP advisor, even if they are a member of the Law Society. So finally, bear in mind, the letter R can be shown, best be shown, because it acts as a deterrent to copycat. If you want more information on trademark IP protection, there are free video tutorials on my website. Think of that, 24/7 access to free tuition. There's lots of articles on my website on IP protection, such as the examples I've provided to you. And after this presentation, Donna is going to be supplying you with a free intellectual property audit document, which you are to freely use yourself or share with your clients. It only takes a couple of minutes to complete and send back to me, and you get a free discussion around some of the risks around you. And on that basis, I'm going to stop sharing. This will be shared online by Donna later. I'm going to be encouraging you now to ask me a few questions, or if you want, share a few stories. Thank you very much.
Thank you so much, Clive. That is, I don't know about anyone else in the room, but to me, that was just incredible, absolutely incredible. Like, we could even have liability as an accountant. It's just mind blowing. But I'm going to pass over to Fred, who's got our first question for you, Clive.
Go ahead,
Right,
Fred.
so you mentioned Companies House, and of course we're
Yes.
all, as professionals, we're now getting our clients to identify themselves and that sort of thing. You mentioned about copycat companies using a different suffix to LTD. How would we know that someone is, so I'm Sallows Associates Limited, LTD. How would I know that someone has gone for Sallows Associates Limited? And therefore, how would I know I'm having my toes trodden on?
Yeah, I always encourage professional advisors to either check themselves every 3 months or 6 months on Google and on Companies House to see if there are potential infringers coming up. But also, please ask your clients to do the same, because we all have a responsibility and accountability to check if these copycats are appearing, because this problem is so widespread, it's so massive now.
Yeah,
and it only takes a minute.
Yeah, so there's no sort of because I set up companies myself, and I don't really put much thought into whether it's limited or LTD or whatever really. So there's no sort of automatic, I can track a company, but I can't track a name. Then I suppose is really what you're saying.
No, you just got to look online every now and again.
Okay, so you've got
due diligence.
Yeah,
regular due diligence.
Yeah, be proactive then, really.
Yeah, absolutely.
Sure. Okay, that's great. Thanks.
Howard, would you like to ask your question?
Yeah, I mean, it strikes me. I mean, I could walk down the high street of the town that I live in, and I could count, probably 20 premises there with a name on them, and 19 of them probably would not be registered. So I'm surprised that there isn't more, I'd call it semi-criminal activity of people registering these names and then popping over to these places and saying, okay, $5,000 and you've got it.
Yeah.
But I never hear of anything like that.
Mm-hmm. There are lots of scams online, sending letters, emails now to businesses, particularly small enterprises, advising those small enterprise business owners that someone else is about to register their trademark, and would they like to do this themselves online with that letter writer. What actually happens is that company who don't know the rules of the game say, okay, how much does it cost? And the and it costs a few £100 to go online and give these people some money online, and they get nothing back for it, of course, because it's a scam. So it's a regular problem. And on my website, I put out a scam alert. I've sent that scam alert to my trade associations to indicate that actually professional law firm websites have been cloned with these letters to indicate to the recipients that actually it could be a legal problem, and they're getting away with it. So it's a massive problem, and it's quite right that you should alert anyone around this problem that you're dealing with, because they're not aware of the rules of the game and how easy it is to clone and copycat identities.
Because you never see, well, I've never seen it pop up on sort of local business forums or Business Scotland or anything like that, protect your trademark. Or if I do, it's so infrequent that it's almost non-existent.
Well, it's not infrequent.
Okay.
Working in the legal fraternity, I know many IP attorneys are earning between £1 and £3 million a year from infringement cases. I know firms employing more than 40 people who are just doing online tracks to identify infringers, selling that information to law firms who then take out court cases. It's a massive problem.
Oh, okay.
Can I ask, Clive, how then does it work with, say, like the likes of Lidl and Aldi, who are clearly out there going, this is Grey Goose, this is our version. They look almost identical, so much so you don't even need to know what the product is, because you can say that's their version of Grey Goose then. How do they get away with things like that?
Well, they don't. They sue each other.
Oh, really?
Oh, yeah. It's very common for supermarkets to be suing each other. It's happened to all of the major supermarkets. When they see a lovely new cake or bottle of booze that's selling well, they'll come out with a copycat, and they'll get away with it for a few months until they're sued, and they have to retract and pay a little bit of money to the other party. But in the meantime, they made a lot of money out of the profits.
But because of the NDA, we never know about it.
Correct.
Wow.
So just to pick up on that then. So thinking of the Aldis and Lidls and thinking, what do they call them? Pringles.
Yep.
So the Pringles pot, I'm surprised, isn't protected in some way as a design, if nothing else. So if I get away with 6 months of selling Pringles at £1 a pop, if you'll pardon the pun and the alliteration as well. So I get away with it, and then I just pay 40p per Pringles pot that I've sold, or fake Pringles, and I've made 60p along the way. So, I mean, do some of these people just consider it the 40p an allowable cost, and as long as they've made 60p a packet along the way, they don't care?
Yeah.
Wow.
I mean, they can be sued, obviously, for profits, as you saw from my examples. But those profits need to be identified and declared, obviously.
Yeah.
But yeah, it's a big problem.
Yeah.
There's a thing going on at the moment with the Dyson Airwrap. I'm seeing a lot of it
Yes.
on Instagram, the dupe. And what the adverts are saying, last few in stock. And what they keep doing is just changing the name of the company that's supplying. So, if you want to buy it, if you did want to buy it and you make an inquiry, when you go back to order, that company doesn't exist anymore because they've moved on to another name.
That's right. Yeah. I mean, if you look wider, things like Airbnb, you've got Airbnb websites being cloned left, right, and centre, people buying the space in advance, paying deposits, and not getting anything back because they're clones, they're dupes.
Goodness. So how can you get away with registering my name, can I just ask? Because surely I'm allowed to be called my name. I've got to write it down on things. I've got it on everything I use. How can they do something as simple as a name?
Well, luckily, Donna, you're not using your personal name as your trading brand, because if you were, you may well be infringing someone who's registered it.
My name! I didn't even have a choice in picking it. My goodness me, it's crazy. I thought,
Stop and look at it though, Donna. Even something simple like an email address. My husband has a very unusual name. There's nobody in the world with a name that's the same. He's Nwalio Abranoza. When he went to do his Gmail, he ended up with 25. Does that mean there are 24 others before him with that name?
Yeah.
And there's not another person in the world that has that name. Go figure.
That's crazy. So in terms of us as advisors, our client, this regularly happens, if he comes to us and says, can you register a limited company for me? Regardless of what's going to happen to them potentially, how do we protect our stance when the client comes in and says, can you do this? What steps should we take so we can negate the risk to our person?
Right. Step number one, put on your website that it's essential before company's house registration takes place that people consider doing a trademark ownership search.
Yeah.
Second, reinforce that when you speak to them. Because if you're doing those two things, you are absolved. That is your get out of jail free card from consequential liability.
Right.
Because if they subsequently decide that they don't want to pay 250 quid or more for a lawyer for a search,
yeah,
that's their risk, not yours.
But you flagged it to them, therefore you can't be held.
Correct.
Perfect.
That flag should be in writing, right?
Yep. On your website, if you want some standard copy on that, I can easily provide that to you.
That I think would be extremely useful, just so we get our wording right.
Yeah.
I, for example, asked them to complete a form, and I would have expected that by filling in a form that said, what would you like to call your company? What would you like me to register it as? That would show that it's client executed almost, so therefore I would be fine. But clearly I need on the top of my form this instruction, so then if they proceed to fill it in below, they've almost accepted that risk.
Yeah, that's right.
Amazing.
Accept the risk, that's their problem, not yours, provided they know the risk.
Howard, go for it.
And how does this work internationally? So I can register a trademark in Australia for New Zealand or something like that. How does that affect stuff in the UK?
Well, if there is a UK firm that's trading online and that trade can be seen by the Australian trademark owner's clients and may be regarded as confusingly similar, then the Australian trademark owner can take action against that company that's trading online, because it's an infringement within Australia because it goes online. If, on the other hand, they're not trading online, they're simply selling something similar in the UK or Europe, then it's not an infringement because it's not actually affecting the trade in Australia.
And that action would have to happen in Australia, I'm guessing.
Yeah.
And that's all very well, but you still got to deliver a notice to somebody and actually get them to pitch up to court.
Yeah, you've got to have a certificate that shows your ownership, and you send that to the ISP and the other party.
Yeah, but it's all very well sending it to the other party, but appear in a court in Australia, and the guy says, well, "Yeah, well, good luck with that."
No, but the likes of Google, Amazon, eBay, Etsy, and all the others have a policy that if they receive a certificate demonstrating that there is an infringement, they will remove the infringer.
Oh, great. Thank you.
Okay.
So breaking it down, just in terms, again, of coming back to our own firms and businesses, if, for example, I or Fred or Fiona or Ben or someone like that wanted to protect our own IP, you've said obviously we need to look at logos, names, domains, and any phrases and stuff. In terms of actual costings, where are we?
Right. So the search fee, you can get a search done for as little as £250 plus VAT. That looks at all the registered trademarks, UK-wide and internationally, all the company's house names, all associated names online using Google. A report is produced, sent to the client, a discussion takes place, all within that fee, and recommendations come out of that report.
Yeah.
So the first step, the search, that's it. Second step is if you want to then register and own, that is a 12-week process through the Intellectual Property Office. You should be using a qualified IP advisor. The IP advisor will be looking at all the different trade activities, putting those into a draft, submitting that draft submission to the IPO online, and then liaising with the IPO for the 12 weeks it takes to process, because it goes into open publishing as well. The costs of that vary. So a law firm will typically charge between £2,000 and £3,000 for that. I charge £450 for that because I focus on the small enterprise market. On top of that fee, there is a fee from the Intellectual Property Office to register it, which is £170.
Yeah.
That covers one particular trading activity. If you've got multiple trading activities, there are smaller additional fees on top. So for each separate trading activity in different classes, as the IPO call it, there's an additional fee of £50. But overall, we're talking about £600 for the actual full registration costs. As I said earlier, that lasts 10 years and is renewable for life. So it's a good insurance.
Oh, okay. So it's 10 years and then
It's not paid annually, it's paid you pay the IPO £200 to renew it after 10 years.
oh, cool. Okay. And obviously, if we're accountants or bookkeepers as we are, and we offer, say, how defined do the service options have to be? So, say for example, Fred, he's a tax specialist, but also does accounts. He offers some payroll. Is that still under the umbrella?
That's one class.
It doesn't go that deep that you have to have one for every service type.
Yeah. But if, on the other hand, if Fred is training his clients in their own accountancy, that's a second class. And that would cost him additional £50 on top of the IPO fee. And I charge an extra £75 on my side. So there's a small additional charge for that extra trading activity.
Crikey, so it's not meant to be good to have too many strings to your bow then in this case.
Well, I mean, I cover a lot of different things as a management consultant, but my trademarks cover only two classes. So I'm an advisor, that's one class. I'm a trainer, that's another class.
But obviously, if any of us wanted to come forward and discuss this with you further with a view to potentially looking to go forward with the process, you'd be able to have a one-to-one with them and say, right,
Absolutely.
You're going to likely fall under this many classes. That would be your cost.
Yeah, I cover that.
Amazing. Does anyone else have any other questions for Clive?
I've got one other sort of supplementary one, I suppose. So in the example of Martha Keith, the lady in the Times article, would, given that it was scammers anyway, would a trademark, a registration actually have protected her? Because the scammers have got their money and run.
Yeah. So she should have registered that product as a design. It would have cost her £50. She should then have sent that design certificate to Google or Amazon, wherever she was selling, and they would have stopped the copycats from appearing online.
But she would only know, well,
as soon as she's...
What I suppose I'm trying to get at, if they're unscrupulous anyway, will they have taken their money and run before she realised that anyone was treading on her toes?
Well, she would have seen those copycats appear quite quickly.
Right.
But without that trademark certificate, she could not have removed them.
Yeah.
If she'd had that certificate in advance, she'd just send it to Amazon. Off they go, same day.
Yeah. And when you say Amazon, do you mean AWS or something?
Yeah. Absolutely. Whoever.
Yeah. So that's quite simple then, really.
Yeah, it's very simple.
Yeah.
I'm just going to let my doggy out the back. There we go. I've got 4 of them at home. They're my security.
Has your dog got a guilty conscience? It's just off to take down that scam website.
She's not got a trademark.
Her name's Binky, and she's going to check the trademark register now.
Yeah, I think so as well, on the payroll.
Oh dear, amazing. Does anyone else have any further questions or comments for Clive?
Just a quick one. Now, I know, not a client or anything, but some people have like a company that's registered with Companies House, and then it's trading as. So this person is an accountant, and it's their name limited, but it's trading as, and it's like their name accounting. So it's like Donna Accounting, but it's like Donna Bedisat Limited.
Yeah.
Trading. So what would they need to? It's
the main distinguishing name that needs to be protected. So Donna is the name that needs protecting.
Yeah.
And when it's trading as, then that is the trademark. You know, that's
Right.
the thing that needs protecting and searching.
Right.
Wow. I think we're all off to Google search our own company names just to make sure we're in prison.
Well, that's the next thing, actually. I don't know if everyone else just did that, but I just looked up like who else uses Ordeo as a name, and there are a couple of like finance ones on there actually. And
If
so
there
I
are,
don't,
if they are pre-trading to your client or to you, they also have unregistered trademark rights, by the way.
right,
They can
Really?
sue the other party for what we call passing off if they're losing business to a copycat who started to trade, even if it's unregistered. Even if they're unregistered, they have rights.
right,
So just a question then on that. My company is In the Detail Bookkeeping Limited, and I agonized over that for months before I set up the company to not have the same name as anybody else. There is an engineering company called In the Detail Limited, and they haven't submitted tax returns since 2020. Completely different company, completely different activity. Would there be a risk of infringement on that?
No.
Right.
The only risk occurs when the other party has got a very well recognized international brand name. Say it's Rolls-Royce. You can't call yourself the Rolls-Royce of accountancy, even if Rolls-Royce aren't accountants or aren't providing accounting services, because the strength of that brand name is sufficient to stop you from using it in another trade sector.
All right. Thank you.
That's a question of judgment, though, isn't it? Presumably.
Yes, it is.
Yeah.
So EasyJet can sue anyone with easy in the name. That's what they've been doing. They've got about 40 suits outstanding at the moment.
I was going to say that example you used, was that a very recent one? Because I read one it's the one I read about the weekend then in that case.
Yeah.
Because they were going first as well, weren't they? Before Stelios actually said, Stelios, who now lives abroad. I think that's where I read it. I think I read it in something that says, man who set up business, moved to Monaco as a non-dom, sues pre-existing UK business or something like that.
Yeah.
Marvellous. Mm-hmm.
So if you've got an existing business, like you said, they've got that passing right. But if you wanted to then register as a trademark, would that overstep that and put you back in pole position because you've bothered to try and register?
The earliest user of the trademark has prior rights. You cannot overcome those prior rights. Yeah. You can still register the trademark.
Yeah.
But they can still trade under their name.
Because they were there before you.
Correct. Yeah.
Right. Okay. Howard, did you want to finish up with our final question?
It wasn't more of a question, but more of an amusing thing. I thought.
Please. We love those.
So get your company to register a trademark in the UK, move to Dubai, sue the companies, capital gains in Dubai or tax-free in Dubai, tax deductible in the UK.
Yeah. It makes good sense, doesn't it?
See, the king of tax, Fred's brains that are wearing away. I can see it. He's thinking, oh, yeah, we're onto something here.
Well, I'm just trying to think if it would be an infringement of the law, whether that would actually be an allowable deduction. So it might not work as a loss in the UK. It might be a capital loss, which you can only carry forward.
There you go. I knew it. I knew he'd be onto it.
Definitely worth a pog, this one, don't you think?
Oh, 1,000,000%. Thank you so much, Clive. You've been extremely helpful. I think this is the most questions we've ever had following any one of our presentations because it is just such a minefield. So thank you again for giving us your expertise and your time. Clive is on LinkedIn, so if anyone wants to connect with him, feel free to check him out on LinkedIn. As he said, he's also offering, I can send you out the slides from today. That's no problem. I'll email those out. And he's also offering a free IP review, which he actually has already completed for me. And there's a couple of red flags I'm already going to have to look into with Clive. So if you'd like to also be scared, then obviously I'll send out that IP and so you can obviously reach out to Clive and get that sorted.
Confessions of an Accountant, where no topic is off the ledger.